You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis, Wright.
Car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with The Attorneys of Hollis Wright.
Hello and welcome. You are watching The Attorneys. I'm Art Franklin. And on this edition of The Attorneys, we're going to dive into a topic that really hits home for a lot of families. We're talking about dependency actions in juvenile court. And understanding how juvenile courts operate is so essential for every parent, every guardian, every relative. So we're going to get into that. But before we do that, we want to tell you right up front, as always, attorneys at Hollis Wright begin manning the phones as soon as this show goes on the air. So right now, you can give them a call. All you have to do is dial 1-844-LAW-TALK. It's a free, confidential call only between you and the attorney who answers that phone, and you can get your question answered there. Or you can scan the QR code on the screen. So we're talking about this topic, talking about juvenile courts. John Spade is here, of course, from Hollis Wright, but we also have with us, so glad to have you, Pooja Chawla, to talk about juvenile court with us. John?
Art, thank you so much for the introduction, and you know, I'm happy to be here. Usually I'm sitting in that chair, but you know, being in the middle here, and we've got a great topic, something that is not something our firm really handles a lot of, or really at all, and so something that I hope the viewers are going to be able to get a lot of insight from, and kind of looking at the juvenile court system and delinquency actions. This is a completely different court. You know, we're a lot of times in circuit civil court, or you know, you might hear criminal court or district court. This is something completely different. And our expert tonight on the topic is the very accomplished, very distinguished Pooja Chawla. Thank you so much for being on the show tonight. And I've got. Speaking of the recognition, the Marquis Who's Who magazine did a feature on you, and you're kind enough to bring that along with you, and I absolutely love that. But thank you so much for coming, and just briefly kind of give a little background to the viewers about kind of, you know, what you do, and you know, then we'll dive into the topic.
Thank you. Thank you for the kind words, John, and thank you, Art. Mm-hmm. I was born and raised in New Delhi, India. And I moved here in 2001. I went to Birmingham School of Law and graduated in 2009. And so right after that, I passed my bar, and I have been ever since practicing as a solo practitioner. This year is my 16th year. Yes.
That's great. And you do primarily family law, is that correct?
Yes.
Okay, well, let's kind of just jump into the topic. We're talking about juvenile court. And I kind of spoke a little bit a second ago about there's all these different types of courts. What are the kind of the makeup of the claimants in juvenile? Obviously, you hear the word juvenile, I think child, young adult. Is there some sort of an age cutoff there? If so, what is that?
Yes, great question. So juvenile courts are run by statute. And whether it's the definition of child, whether it's the age of child, whether it's the kind of claims that can be brought in that court. So for example, a delinquency act where a child is alleged to have committed an illegal activity or is charged with something that's not legal, that would be juvenile court jurisdiction. A dependency action where a neighbor or an agency like DHR or a relative think that the child is not safe, that the child is being neglected and needs an adult supervision, they can come to juvenile court and file a dependency petition, and that's when the jurisdiction attaches on that particular child. So once the jurisdiction attaches, then the court has jurisdiction until the child reaches the age of 21. But there is some caveat to it, which we'll discuss in furthermore. But other cases that are generally brought upon in juvenile courts are paternity actions, where the fathers want to establish paternity, child support issues, custody modifications, even grandparent visitations. So all of those also come through juvenile courts. But again, it goes back to what was the original jurisdiction when the case started for the people to be asking for modification or any of these new items.
Okay, and so you got the type of claim, and then there's an age component as well.
Yes.
And I think you said it might be a little bit nuanced as far as the age. I think you mentioned 21. I've heard 18. It kind of plays in that. Can you explain the age, just kind of briefly, how that plays a role in juvenile court?
Yes. So generally, the age is the age of the child is defined as 18 years old is a child, and that after that, the court kind of loses its jurisdiction. Now it continues to attach the jurisdiction if there was some issue that was to become about. So the issue, if it's the same issue that was originally brought upon in the court can continue to have that jurisdiction. Now, however, this came about in an appellate brief that I worked on a couple of years ago, which I also do a lot of appellate work for termination of parental rights for the parents. I represent both the parents, it could be parents or the child, depending on which side I am on. And termination of parental rights in our area of juvenile court, we call them as death penalty for the parent. So, we handle them very diligently. We have a very short amount of time to bring them back to appellate court. But in this case, it is called ML versus Jefferson County Department of Human Resources. I represented a parent, and the issue that I presented oral arguments in front of Court of Civil Appeals was, the issue was whether the juvenile court had jurisdiction over this child where the child had reached the age of 18 at the time of trial. So if the juvenile court had jurisdiction to terminate the rights of the mother where the child had already reached the age of 18. And the Department of Human Resources argued that the court continues to have jurisdiction until the child is 21 years old. And my response was, you're absolutely correct. However, the statute calls whenever the termination of parental rights trial is held, at that point, at that junction, the court is to find the child dependent again before going on the custody disposition. So for the court to have found the child dependent, the child have to be under 18 years of age. However, in this case, the child was over 18 years of age, so the court had lost that jurisdiction to find the child dependent. And therefore, appellate court agreed with my arguments and ruled in my favor, and the appeal was dismissed.
That's great. It's fantastic. And we talked about termination of parental rights, and I think you call it a death sentence, basically. I mean, it cuts off
Yes.
any custody,
Yes.
right, of the child.
Yes.
Is there a kind of a step down or another option other than just, I guess, full termination of rights? Is there like a temporary option or anything like that? What are kind of some of the other, because I'm sure custody is something that you deal with a lot in your practice. What are some of the other options that the court has?
So when the case starts, let's go. I think that would help us. When a petition is filed, a parent is notified. There is a hearing called 72-hour hearing or shelter care hearing, because those hearings have to be held within 72 hours of a child being picked up, removed from the parent. So at that point, the case starts. Now, if the child, after that hearing, if the court concludes that the parent needs rehabilitation or whatever the situation is, if it's safety or neglect, up until the parent has reached that rehabilitative state, the child is going to stay either with a relative or foster parent, and so the case moves on. And the court monitors the progress via every so few months hearings, 60 days, 90 days, everybody come back to court, parents are provided some services, and if the Department of Human Resources is involved, They provide them with service providers, they provide them with referrals, and so the court monitors the progress. What progress has parent made? And based upon that progress, if it's safe for the child to reunite, the child and parent are reunited. However, there are circumstances, and it's unfortunate, and sometimes it's not, they're not in our control, where the parent is unable to find a job, or they have lost their housing to a fire in the middle of this, so they don't have stable housing, but they cannot move forward in the case. And at that point, the petition for termination of parental rights will be filed. So up until the day of the trial, the parent still has that time to work through and be reunited.
And during that time, there's still some temporary rights. They're not living at their home, or
Yes.
kind of what we kind of typically think of as a nuclear type family. So there's some temporary rights that have been suspended, and they still have some temporary rights. But then ultimately, if there's a complete termination, that's end the road and kind of I don't want to say clean break, but there's no rights there.
Right.
Fair?
Yes.
Okay.
Yes.
So we're going to take a break right here. Go ahead and take a break. We'll continue the discussion in just a minute, but I want to also remind you to follow Hollis Wright on all the social media channels, on X, Instagram, Facebook, YouTube. Great content there. We'll take a break. We'll be back right after this.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery. Find community.
At Bradford.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
Welcome back. You are watching The Attorneys, and we're helping families understand their rights in juvenile court dependency action, and also reminding you, you still have time to get in contact with an attorney at Hollis Wright at 1-844-LAW-TALK for a free, confidential consultation with one of our attorneys there. One of our attorneys is sitting right here next to me, John Spade, as we are talking about this juvenile court.
Yeah, and let's pick up the conversation. We kind of went through generally the process, kind of a 30,000-foot view. But let's talk about dependency in particular. Who can file dependency claims, and kind of, I think you mentioned earlier that do you represent children sometimes and adults on the other side, and kind of talk through kind of that on both sides of the coin here. But first off, who all can file dependency claims?
Great question. So yeah, back to be on ground zero and back from the 30,000 view. So any person, whether you are an aunt, you're an uncle, you are a parent who is living with or not living with the child, you are a grandparent, an agency, anybody who has concern for the safety, abuse, neglect of a child can file a dependent petition with the juvenile court. There is a magistrate, there is an intake officer who verifies the petition before it's filed with court. And once it's filed, like we talked before, it's set for a 72-hour hearing.
So that filing that petition kind of more or less gets the ball rolling and says, it could be anybody, says, hey, something isn't above board here. I would like somebody to get involved to take a look at this and just make sure that at the end of the day, that this juvenile is being taken care of, and we're looking for the best interests of the children who might not have a voice in this situation, or might not know where to look. So that petition kind of gets it rolling. Is that
correct?
Fair? Yeah. Okay.
Yes, and we have seen cases being filed through school system where a child feels he or she appears to be malnourished or does not look appropriate clothing, does not look like has bathed in a while. So those concerns can mount up to be of that would qualify for a dependent petition. We have seen hospitals file for these petitions if a parent brings in the child, but the doctor determines that this is beyond the level of the care that the child should be receiving appropriately. If the child was going to pediatrician, they can call DHR and further investigation is done before the petition is filed. But like I said, it can be an agency, it can be a person.
Okay. Anybody that's concerned. Now, we've got the petition filed and the 72-hour hearing. If I've got 2 children, and I would be absolutely wrecked if something like this were to happen. But I think a lot of parents and caregivers out there are, well, if this were to happen, can I hire an attorney? They might not. They didn't go to law school. They don't practice law. What rights do the parents have in these situations? And then on the other side of that, on the children, do they have somebody that's advocating for them as well?
Yes. So let's talk about the rights. The parents have the right to be notified of these hearings. They have the right to be present at all the hearings. They have a right to have an attorney. Now, the right to attorney, let's talk about that. If you are unable to afford an attorney, you file something with the court called an affidavit of substantial hardship, and if you qualify, the court can appoint an attorney for you. However, if you do not qualify, I highly recommend, have been working in this field for so many years, that reach out to an attorney and have an attorney present in these proceedings, because they may look like just going to court and reviewing what you need to do and do it, but the process of reunification and the nuances that come along with it, they can get complicated before you know.
And there are some, depending on where the action is pending, but let's say in Birmingham, for instance, I know you did some work with like the Birmingham Bar and the Alabama Bar as well. There are services through the Birmingham Bar and the Alabama Bar if, for instance, you aren't able to come out of pocket immediately and hire an attorney. There are some avenues where you can contact your local bar association, and they can help provide pro bono counsel for you in limited circumstances. Is that another kind of avenue that you can use?
You could. I think you would have to reach out to those organizations specifically to see what kind of lawyers they have to provide what kind of services. But like I said, if you do qualify for affidavit of substantial hardship, the court has attorneys that they can assign the cases to. So the court has a ready system to go, built-in system. But yeah, if you do not qualify, then I'm not sure if you would qualify to get that pro bono assistance either, because they look at the same
kind of measuring.
It's the same kind of measuring. Yes.
Okay. Go ahead, Art.
You know, in juvenile court, too, I think there are a lot of protections for the privacy of the juvenile. So when they're in court, a lot of parents may be concerned, my child committed or alleged to have committed a juvenile delinquent act out there, and they're concerned about whether that information or that case is going to be open for everybody to see. Is that a situation that's going to be protected to protect that child?
Yes, that's a great question. So these cases are considered very sensitive. They're very sensitive in nature. It doesn't matter if it's dependency or delinquency or paternity, whatever it is, they're considered very sensitive. And so to protect the privacy of everyone, these are very closed hearings. Public is not allowed inside. It's just the attorneys, the parties. Even let's say it's mom and dad, and there is a grandma who is visiting from out of town, but she wants to be inside the courtroom. The grandma is not going to be allowed inside the courtroom because she's not a party to the case. So these are those closed hearings. Very, very protective of the families and the children.
All right. Well,
Yes.
we're not done.
And I did want to circle back on one question that you had asked earlier, the rights of the children in this case. We had talked about rights of the parents. So the children also get an attorney to assign to them, who is called a Guardian Ad Litem. So that person is certified by state. You have to get your certification each year, have to keep it current. I myself am a certified Guardian Ad Litem, and that's why I work both with children and with families, with parents. I serve both sides.
And that's part of your passion.
That's part of my passion, yes.
That's right.
Yes.
Well, we're going to take a break here, and we're going to wrap up this discussion when we come back, as we're talking about juvenile court and the protections that parents would have and the children would have as well. I want to remind you, though, you still have some time to get in contact with someone at Hollis Wright right now, one of the attorneys standing by to hear from you. All you have to do is scan that QR code on the screen or call 1-844-LAW-TALK for a free confidential call. Also, follow Hollis Wright on all the social media platforms, on X, on Instagram, Facebook, and YouTube. Great content there. You'll see some behind-the-scenes stuff. You'll see some legal information. We keep you informed. Stay with us. We'll be back after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK, and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
Welcome back to The Attorneys. You've got just a little bit more time left for an attorney to actually man the phone so you can reach someone live at Hollis Wright. So go ahead and call right now if you have a question. It's 1-844-LAW-TALK, 1-844-LAW-TALK, or scan that QR code on the screen and you can reach someone that way. John Spade, we're in the home stretch on this topic of juvenile court.
Yes, we are, and I want to talk about, we've talked, Pooja, about kind of the process in general and these types of claims, and how both sides need to have somebody advocating for them, especially these minor children. What happens though, and kind of take us through once the court gives an order, say a custody order, for instance. is that game over and everybody kind of takes their ball and goes home, or is there an appeal there, or kind of what happens after the court gives a final order in one of these cases?
Okay. So I want to clarify, like, are we saying a termination of parental rights order or just a order? Because there are different ways you can appeal it.
Yeah, let's talk about the termination of parental rights.
Okay,
let's
all
do
right.
that. Yeah.
All right. So if you get one of those orders, first thing the attorney would do for you is file a motion to alter, amend, or vacate that holding, which has to be done within 14 days of the issuance of the order. And once you receive an order on the motion that you filed with the court, which is a post-judgment motion, once you receive that order, again, you have 14 days to file an appeal with the Court of Civil Appeals. So 14 days is the magic number. And if you miss the deadline, then good luck to you.
And that's a pretty short.
That's a pretty short window.
So we're sitting here talking about it 14, but those 2 weeks fly by pretty quickly.
Yes, and they do include weekends.
Okay.
Yes.
That's important for the viewers to know as well. Just real quick, let's say we got a custody order or a parental rights order, and the case was pending in Alabama, and then the parents moved to Tennessee, for instance. If they wanted to amend that order or change the rights in any way, who has jurisdiction over that initial order that came out of Alabama? Do you file it where you're now living in Tennessee, or is it back in Alabama?
So if it's one parent who moved, let's say it's one parent who moved to Tennessee, and the other parent is still here in Alabama. Are we talking that situation?
Yeah.
Okay. So let's say mom is here with the kids and dad has moved to Tennessee, and dad says, I want to now gain custody of the children. So since I live in Tennessee, the closest court to me is Tennessee. I'm going to go file in Tennessee. The Tennessee court cannot have jurisdiction because, again, it's run by the statute. Once juvenile court has jurisdiction over a child, it has continuing jurisdiction. So dad can come back to Alabama and file for a modification. The dad will have to show material change in circumstances. He'll have to meet a burden of proof, and the court will set it for a hearing and have the ball rolling. But it will have to be done not just within Alabama, it will have to be in the same county where the last court order came from.
So that court retains that jurisdiction. And there's so many nuances in these types of cases, which is why it's so important to contact an attorney. And obviously you're extremely experienced on representing not only children, adults as well, and parents as well. So if anybody has a issue, I would highly recommend reaching out to Pooja. Thank you so much for coming on.
Thank you.
Art, I appreciate it.
But yeah, good to see you, John, and thank you again, Pooja Chawla. And thank you at home for watching or wherever you're watching. And make sure you put it on your calendar to watch us again, same place, same time, for another edition of The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.